Okay, everyone, lots of new filings in Don Lemon's criminal case, including a motion to dismiss the indictment filed by all of the activist-defendants jointly, except for Amelia Hansa. So the defendants who didn't join in this motion to dismiss are the journalist-defendants, including Don Lemon and activist-defendant Amelia Hansa. Now, maybe her argument now is that she's a journalist. In any event, they'll probably file their own joint motion to dismiss the indictment shortly. The journalist-defendants claim they were just at City's Church reporting on the incident, not participating. And let's acknowledge that the activist defendants here seem to be taking responsibility for putting the journalist defendants in the position that they're in. That is to say, being criminally prosecuted. The activist defendants are willing to separate themselves, in other words, and they seem to be telling the court, train your fire on us, not them. Now, the public and the media certainly might go for a narrative like that, but what about the government? No. Now, this happens sometimes in criminal cases. A defendant will confess to someone else's crime to help that person or maybe spare that person the punishment. But the government doesn't allow that, okay, because an accused criminal is going free upon a false confession. Now, maybe the journalists were caught up in emotions and the power that they felt during the takeover-style attack on City's Church. And so the government will require them to take responsibility for doing that, as they are alleged to have done. So, if there is an effort to be noble toward the journalist defendants by the activist defendants, the public and the media might love them for it, but the government will treat it as a false confession. Now, before I get to the motion to dismiss, there's a motion to modify conditions of pretrial release filed by the government against defendant Ian Davis Austin, one of the activist defendants. Now, here he is at the anti-ICE protest outside of Delaney Hall, the immigration detention center in Newark, New Jersey. Huge protests there. Co-defendant Austin was arrested at least twice. New Jersey State Police arrested him on June 2nd for endangering another person and disorderly conduct. Now, the feds arrested him a few days later on June 6th, but the U.S. attorney in New Jersey declined to prosecute. Now, the New Jersey police released him after the arrest. A hearing is set for June 30th, this coming Tuesday in that case. Now, if the hearing on June 30th is a detention hearing, potentially he could be detained pending trial on the state charges because he has an open case, the federal case for the attack on City's Church. So, the open case is some indication that no set of release conditions would reasonably assure the safety of the community. He was charged with endangering another person in New Jersey. So he could be detained pending trial in New Jersey. The government in the City's Church case with this filing is alerting the court that he seems to have violated his release conditions. Now, the issue here is that several months ago, the federal public defender filed a chart indicating, among other things, that co-defendant Austin had no conditions on his release except to stay away from City's Church. So the government's filing doesn't seek to revoke his release conditions at this time, I believe, because it's unclear at this time what his release conditions are. Now, the government may have filed this request for a hearing to clarify whether co-defendant Austin knew he had any release conditions imposed and whether there are any imposed. Now, the federal public defender several months ago said, no, there are none. The government here is asking, is that right? Now, I noticed that the government's filing is signed by both the U.S. attorney and a trial attorney from DOJ's Civil Rights Division. Now, he signed the filing himself and identified himself as a trial attorney. So, in my view, the government is preparing for a detention hearing on this co-defendant. Despite saying in this filing they're not seeking an evidentiary hearing at this time, and instead are just asking for a raft of conditions to be added to his pretrial release, including the requirement that he maintain active employment. He's not employed currently. He's a former combat veteran who's currently undergoing mental health treatment. Now, the government said in the filing that it wants mental health treatment imposed as a new release condition, but his defense attorneys responded by saying, he's already receiving psychiatric treatment. Don't you know anything? So, if I understand his defense argument, he should be allowed to continue protesting around the country, getting arrested multiple times, etc., because his goal is to develop a cult following like William Kelly, a.k.a. DaWokeFarmer, who has a GoFundMe page to raise money for his First Amendment activities, quote unquote, and he's raised over $100,000. So that seems to be the goal for defendant Ian Davis Austin as well. His goal is to become a paid protester, it seems. Regardless, as soon as his current release conditions in the city's church case are clarified, the government probably will seek to revoke those release conditions, if there are any, and impose new, more restrictive pretrial release conditions. Now, on to the motion to dismiss indictment. It's joined by 33 of the activist defendants, including the leaders of the alleged conspiracy. Nakima Levy-Armstrong, I've been pronouncing her name incorrectly, I apologize for that, and Chantel Allen, as well as the hype man William Kelly, a.k.a. DaWokeFarmer, joined by Ian Davis Austin as well, the aspiring hype man. Now, the motion to dismiss says that the indictment fails to state an offense against the co-defendants. Am I convinced by that argument? No. For instance, the motion to dismiss says that the indictment doesn't even specify what civil right is being attacked by the defendant's conduct. Now, it's the civil right of religious worship, obviously. Now, this type of attack against a house of worship could be aimed at any religious group or gathering. Now, this motion to dismiss the indictment was written by the defense attorney for co-defendant Thomas Matthew Tier, whom we haven't heard from a lot yet. Now, he's hired a high-profile law firm, which may be working pro bono. Now, I'm looking forward to the government's opposition. The DOJ's Civil Rights Division has been destroying the defendants, metaphorically speaking, with all previous filings. So I'm looking forward to that opposition, which will be filed soon enough. Now, finally, last week, the court denied the defendant's motions to disclose grand jury materials. Now, that decision is being appealed to the district judge in the case. And last week, the government voluntarily disclosed some parts of the grand jury testimony regarding co-defendant Georgia Fort. Now, this week, the government says it released even more testimony in camera to the judge in chambers regarding Georgia Fort. We may get the disclosures as well to the extent that they're referenced in public filings. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.